We are so excited to have you in class today. Today's class topic is looking at the First Amendment and diving deep into speech and press over American history and today's modern questions. My name is Kerry Sautner. It's great to have you all in class today. As we go through class, feel free to ask questions. We love questions. We'll be asking you questions, so be ready for that too. But you can use the Q&A or you can use the chat function, either one that works great for you. Now, to go through all of this, we're here with the National Constitution Center's top scholar, Jeffrey Rosen. So Jeff, so great to have you in class today. Are you absolutely excited about this topic?
Well, I sure am, Kerry. It is hard to think of a more crucially important, exciting, and significant topic than the First Amendment. And friends, here's what I hope we will do together during our time today. Let us first read the text of the First Amendment, and then I will share with you the extraordinarily speech protective test that the US Supreme Court embraced in 1969 for the circumstances under which speech can be regulated. And then we'll talk about where that test came from, and then we'll talk about how it applies today to questions ranging from the ones that are right in the news, like whether or not former President Trump incited a mob when he gave a speech on the mall. That's a question that the Senate will be considering in its impeachment trial next week, as well as will be raised in federal courts. And we'll also talk about questions like the circumstances under which your teachers and principals can regulate your speech online, as well as questions involving whether Facebook and Twitter can ban speakers from their platforms. So there's so much to talk about, and my job is to do it as intensely and efficiently as possible. So you're excited and you get the major parts of the doctrine. Okay, so let's begin with the text, which I think we can pretty well do from memory, but here we go. Congress shall make no law abridging the freedom of speech or of the press. My law school professor, Owen Fiss was his name, great teacher, so inspiring, used to always say, the freedom of speech. What is the freedom of speech? And he put a lot of emphasis on the, suggesting it's not just freedom of speech, but the freedom of speech. Now, you can decide for yourself whether or not the addition of that the makes a difference. But let's just now cut to the central doctrinal point. How has the Supreme Court defined an abridgment of the freedom of speech? In a case called the Brandenburg case in 1969, the court said that speech is so important to protect, even hateful speech is so important to protect against government regulation, that speech cannot be regulated or abridged by government unless it is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Those are among the most significant words of legal doctrine in all of our Supreme Court canon. So let me read them again. The speech has to meet two tests. It has to first be directed to inciting or producing imminent lawless action. And second, it has to be likely to incite or produce the action. When I talk about this test, I often talked about it imprecisely by saying the speech has to be intended to and likely to producing the imminent lawless action. That's not what it says. It has to be directed to inciting the action and likely to produce it. But whether you say intent or directed, you understand how restricted that speech is. So let's say one of you in the chat said, Jeff is boring. Go shoot Jeff now. Now that would be a really inappropriate thing for you to say in the chat. I hope you don't say that, and I hope I'm not that boring. But if you said that, would that meet the test of being directed to and likely to produce imminent lawless action? I don't think so. I think most of us, including me, would say, well, that sure is rude and inappropriate, but you weren't actually intending to or directing your fellow students to committing violence against me. And it certainly wasn't likely to produce any violence because we're on Zoom right now and there's no mob waiting outside my house that's about to threaten me. Now, if you started a campaign against me online and said, Jeff is so boring, I really don't want him to come back on Wednesday. Let's have Tom Donnelly. He's so much more exciting. And you started a chat group on Reddit or on Facebook and started making threats and telling people to gather outside my house. Now, that would be a different story. And that's one of the issues in the impeachment trial and in potential indictments under the Insurrection Acts against some of the people who mobbed the Capitol. To what degree did they use online platforms to produce violence? You know, there the speech was intended to, and likely, arguably, to incite the violence, and the online platform was the means for it. I say all this just to emphasize how hard it is to regulate speech in America. Can you regulate the speech because it is hurtful and offensive? Let's say you just said, Jeff is boring. Of course, that wouldn't meet the test. Let's say you used an epithet to describe me. You used a hateful epithet. That wouldn't count either. It would have to literally be directed to and likely to produce imminent lawless action. We're the most speech protective country in the world because of that. No other country imposes such strong limits on the government when it comes to regulating speech. If we were in Europe and we were teaching this class and you tweeted after the class, Jeff gave the most boring lecture on free speech ever. He is a terrible teacher. Then I could claim that you violated my dignitary rights. And in Europe, there's an amazing right that can be enforced called the right to be forgotten, or it comes from the French, the droit à l'oubli, which means the right of oblivion. And basically, the European Court has said that all European internet users can exercise this right. And anytime anyone objects that a particular post on the internet has violated their dignity, they can claim that it violates their right to be forgotten. And then Google has to make a judgment about whether or not the speech is in the public interest and whether or not its public value outweighs the dignitary offense. And if Google guesses wrong and doesn't take down the post and is later second guessed by a privacy commissioner, it's liable for up to 2% of its annual income, which was something like $70 billion last year. So that concentrates the mind, and Google has removed about 42% of the requests for takedown that it's gotten in Europe, including posts about the right to be forgotten itself. So I tell you that story just so you have a sense of how incredibly protective the First Amendment is in America and how no one else in the world embraces such a strict standard. Now, I have to tell you, where did that extraordinarily speech protective standard come from? And it dates back to the founding, and it dates back to clashes over free speech at the very beginning of our nation involving something called the Alien and Sedition Acts. But before I launch into that story, which is so exciting and so interesting, I'm going to pause and ask Kerry if you want to bring in any questions.
I do, just for longer term, because you know how I love the Alien Sedition Acts. We should definitely go over those, and then Holmes and Brandeis. But Warren brought up something really important in the chat, and I wanted to share it. If we can think about and compare what happened in Russia over the weekend, just to look a little globally too, and speech and protest as well. I just wanted to kind of weave that in because it really is so different than any other country, like you were saying, and we can see it in our news every day. So weave that in as you go along.
Yes, well, in Russia, we have a critic of the government, a critic of Prime Minister Putin, who issued a video showing the extraordinarily lavish palace that he basically had built for himself by his supporters. And people were so outraged by these videos that they protested. And in Russia, of course, there's no protection for freedom of speech or assembly, and the government is free to suppress speech without proving that it's intended to and likely to cause imminent lawless action. So it's impossible to imagine a more dramatic contrast between two countries than the US, which has this extraordinary free speech tradition, and Russia, which, alas, has nothing of the kind. Let us now talk about the roots of the American free speech tradition. And I want to just jump to the Alien and Sedition Acts in 1798. So it's 1798, and the Adams administration is concerned about its critics. The justification, as always, is a national security justification. The claim is that there's a war over the Britain and France, and the Adams administration is siding with Britain, and there's evidence that the French are trying to bribe American ambassadors, and the Jeffersonians are siding with France, and the Adams administration with Britain. So the Adams administration decides to stack the deck against their political opposition, and they pass a law making it a criminal offense to criticize the Federalist president, John Adams, but not the Republican vice president, Thomas Jefferson. Can you imagine a more we would call it non-content neutral is the jargon, but basically a more politically discriminatory law? You can't criticize the president, but you can criticize the vice president. Obviously, it was intended to immunize the president from criticism. Now, under the established law of this time, that wasn't obviously unconstitutional. The British law of sedition, which means criticizing those in power, had said that truth is no defense against seditious libel. In fact, the greater the truth, the worse the offense. If you said something really mean about the King of England, if it was true, that would make it worse. In the US, the claim was we're going to abandon the British rule and at least allow truth to be a defense against seditious libel. But that still left broad realm for criminalizing speech that, was a matter of opinion and offended the dignity of the president. Now, Jefferson and Madison thought that that was not protective enough. And they believed that our rights of speech and conscience come from God or nature, not from government. And they are unalienable. And they believe that our opinions are the product of external sense impressions operating on our minds, because they were empiricists and people of the Enlightenment. And they thought that the combination of these external impressions and our reason produced our opinions. And I can't alienate or surrender to Kerry or Warren or anyone else my power to form my own opinions, because it's the inexorable and unalienable process of my reason reflecting on and deliberating on these external sense impressions. So that's why Jefferson and Madison in the Virginia and Kentucky resolutions said that the Alien and Sedition Acts were unconstitutional. And Madison said that the powers of speech are fundamental. And he said in particular, this power to regulate speech ought to produce universal alarm because it is leveled against that right of freely examining public characters and measures, and of free communications among the people thereon, which has ever justly deemed and been the only effectual guardian of every other right. So, in other words, because it's so important to communicate thoughtful, deliberative opinion, and that's the only way to hold our representatives accountable to the people, the rights of speech cannot be regulated. It's the crucial ideas about accountability. And Jefferson, when he became president after the election of 1800, allowed the Alien and Sedition Acts to expire and pardoned those who were in jail for committing offenses under the acts. So that's the core controversy I want you to keep in mind, that originally the government tried to ban sedition or criticizing public authorities. Madison and Jefferson said that that was unconstitutional. And the Supreme Court soon came, or not soon, but eventually came to recognize the wisdom of Madison and Jefferson's objections. But it did so for different reasons. And I told you the rule, speech can't be banned unless it's too directed to and likely to produce imminent lawless action. But why? What's the reason for that? And you can't embrace the rule unless you know the reasons. So fast forward to World War I. And that's when the First Amendment, as we know it today, didn't begin to emerge. And once again, we have an administration, this time led by President Woodrow Wilson, who wants to criminalize the speech of his critics. And people are criticizing World War I, and Congress passes the Espionage Act of 1917, soon after the US enters into the war. It makes it a crime to convey information intended to interfere with the war effort, and imposes harsh penalties for dissenting speech. The Wilson administration prosecutes thousands of anti-war activists, and one of them, I want you to remember this name because it's just such an amazing story, Eugene V. Debs. Who is Eugene V. Debs? He's a pacifist labor organizer, one of the founders of the International Workers of the World. He runs for president in 1900, 1904, 1908, 1912. He has to run for president in 1920 from a jail cell because he's imprisoned for a mild speech that he made criticizing World War I a few years earlier. It was in 1918. Basically, Eugene V. Debs is the Bernie Sanders of his day. He calls himself a socialist, and he thought that the war was a war fought by the capitalists against the people. And he gives a speech saying that, and he's punished under the Espionage Act. And the majority of the Supreme Court upholds his conviction on the grounds that his speech might have a bad tendency to produce lawbreaking, namely not obeying the draft. You see how loose that test is? Eugene V. Debs says, don't enlist in the war. It's a bad war run by the capitalists against the people, because some people might listen to his speech and not obey the draft or enlist in the war. The speech has a bad tendency to encourage lawbreaking. Don't you see the difference between that bad tendency test and that really firm test that we began with, directed to and likely to produce imminent lawless action, is very different from a test that says the speech has to have a bad tendency to possibly produce some kind of lawmaking. First of all, you miss what's effectively an intent requirement or a focused purpose requirement. It has to be directed to or intended to producing the bad action. And then the bad action has to be imminent. It's not enough that somewhere in the future someone might possibly heed it. So that's where all of the action comes. How close are you going to require, how close a connection between the speech itself and the lawless action to follow? Now, the US Supreme Court upholds Eugene V. Debs's conviction, as well as those of many other anti-war activists. But the Espionage Act produces two of the greatest separate opinions about free speech in Supreme Court history. One is written by Oliver Wendell Holmes, the other by Louis Brandeis. Both are beautiful examples of constitutional poetry. I want to read both of them because each of them has a very different vision of the purposes of speech, and I want you to decide which one you find more persuasive. So let's begin with Holmes in the Abrams case. There's a great book called The Great Dissent, and it's by Thomas Ricks. And if you want a really beautiful encapsulation of the dissent, how it came to be and what it means, then please read this great book called The Great Dissent. But I'm just going to look, I want the full speech.
And as you look, don't worry, students, if you can't find it, we'll make sure we send it out to you in the Friday wrap-up email. So you will get the link to the book and the speeches and the Great Dissent, the direct dissents as well.
Totally. Okay, here we go. So this is Abrams. My internet is acting up. So I can do the Brandeis from memory as a party trick, but I've got to wait for the Abrams case to come up. Well, you know what I'm going to do so you don't have to wait. Let's talk about Brandeis in the meantime, because that one I can do from memory. So Brandeis is another case. It's called the Whitney case, Whitney versus California. And Brandeis writes a separate opinion. It's a concurrence, not a dissent for technical reasons. But here is Brandeis's account of why speech is important. He says, those who won our revolution believed that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty. That's a quotation from Pericles' funeral oration. They believe that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. That without free speech and assembly, discussion would be futile. That with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine. That the greatest threat to freedom is an inert people. That public discussion is a political duty, and that this should be a fundamental principle of the American government. Wow, it's just constitutional poetry. It is so glorious. And the core idea from Brandeis, as you heard, is his transcendent faith in the power of deliberation. As long as there be time enough for deliberation, the best response to evil counsels is good ones. He has such faith in reason, like Jefferson, because he was a Jeffersonian, that he thinks instead of suppressing hate speech, we should counter it with reasoned arguments so that people can deliberate and that ultimately reason will prevail. Now, there's a crucial qualification that Brandeis include, if there be time enough for deliberation. And one important question is, in the age of the internet, when speech travels at warp speed and when disinformation travels further and faster than truth, was Brandeis too optimistic about giving time for deliberation, given the quickness with falsehood spreads? But let's call Brandeis's the public deliberation theory of speech, and it has transcendent faith in the power of reason. Now I'm going to put Holmes's competing theory on the table. I know this is a lot to share, but I want to just get it all on the table, and then we'll talk about it. Holmes has a different theory, equally beautiful, equally powerful, but less idealistic, that with deliberation, reason will prevail. Holmes's theory it's known as the marketplace of ideas theory. And basically, he thinks he's not confident that truth will prevail, but he thinks that the alternative to allowing speech to have its way and to be tested in the marketplace is violence. Holmes served in the Civil War, and he was almost killed at Antietam, where 23,000 people died or wounded, the bloodiest day in American history. And he's so skeptical about the power of absolute truth that he thinks that you have to allow popular opinions to crush unpopular ones in the marketplace of ideals, or else open warfare will result. So it's a far more, well, let's call it a far less idealistic theory than the deliberation theory, this marketplace of ideas theory, but he expresses it in words that are equally beautiful. So this is Holmes in the Abrams case, and listen to his beautiful language. Persecution for the expression of opinions seems to me perfectly logical. If you have no doubt of your premises or your power and want a certain result with all your heart, you naturally express your wishes in law and sweep away all opposition. To allow opposition by speech seems to indicate that you think the speech impotent, in other words, powerless, as when a man says that he has squared the circle, or that you do not care wholeheartedly for the result, or that you doubt either your power or your premises. But when men have realized that time has upset many fighting faiths, they may come to believe, even more than they believe the very foundations of their own conduct, that the ultimate good desired is better reached by free trade in ideas, that the best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which their wishes safely can be carried out. That, at any rate, is the theory of our Constitution. It is an experiment, as all life is an experiment. And that's just so amazing, isn't it? Just that, both that idea of the power of thought to get itself accepted in the competition of the market, the idea of the competition as an experiment. He's not confident that he or anyone else actually knows the right answer or the truth, but he thinks that ultimately this competition of the market is the only test, so that the experiment can work. And then he gives us a version of the imminence test. He says, every year, if not every day, we have to wager our salvation upon some prophecy based on imperfect knowledge. While that experiment is part of our system, I think we should be eternally vigilant against attempts to check the expression of opinions that we loathe and believe to be fraught with death, unless they so imminently threaten immediate interference with the lawful and pressing purposes of the law that an immediate check is required to save the country. Wow, I mean, that's a really strong test, isn't it? The speech has to imminently threaten immediate interference with the lawful and pressing purposes of the law, and an immediate check has to be required to save the country. A version of that test that the Supreme Court finally adopts in 1969 in the Brandenburg case that we began with, that the speech has to be directed to and likely to produce imminent lawless action. Okay, there you have it. You have the text, you have the Alien and Sedition Act, you have this incredible story of World War I, and then you have these two powerful, complementary, but distinct visions of speech. One, Brandeis's theory of reasoned deliberation as producing truth as long as there's time enough to deliberate. And the other, Holmes's idea of the marketplace of ideas, both leading to the same test that speech cannot be banned unless it's intended to and likely to cause imminent violence. Okay, now I will pause. And Kerry, why don't we have a little bit of discussion?
Great, because we have at least 7 questions for you. So Angelina, clarifying question, we'll start there. When you say Jeffersonian, what exactly do you mean by that? Just so we clarify we're on the same page, and then we're going to dive into this.
By Jeffersonian, I mean only that Jefferson and Brandeis and Madison believed that speech was a natural right, which means it didn't come from government. It wasn't created by the Constitution. It comes from nature or God, or it inheres in us. And it comes from what Brandeis called, and his language is really important. He said they, the founders, believed that people have a duty to to cultivate their faculties of reason, and that in its government, the deliberative forces should prevail over the arbitrary. Jefferson believes that we all have certain faculties, ranging from reason, which is the highest faculty, to the passions or affections. Passions were the 18th century word for emotions. And the founders all believed, like the ancient philosophers, that we have a duty to cultivate our faculties of reason so it can check and temper and moderate our selfish and unreasonable passions, like anger or selfishness or ambition or avarice or jealousy and fear. And it's only by basically taking the time to stop, take a deep breath, deliberate, and check our selfish passions that we can be guided by reason rather than by selfishness, and we can serve the public good. So it's a theory that's central to the entire, to all of the philosophy, starting from the ancient Greeks and Romans to the 17th and 18th century, this clash between reason and passion. But that's what I mean when I say Jeffersonian. It's this, that's what Jefferson and Madison believed. That's what Brandeis believed, that we have a responsibility to cultivate our faculties of reason so we can overcome our selfish emotions. And the only way we can do that is with the time to deliberate. That's what I meant.
Great. So, and again, these are kind of like wrapping around the ideas into what the students hear. So in the Santana class, Alicia asked, what is the meaning of free speech and how far can you take it? But another student from that class asked, what exactly is hate speech? Or is that just is freedom of speech with a label on it? So can you kind of and students hear that all the time, oh, that's hate speech, But what is it really constitutionally? What are we talking about?
Great question. So there's no constitutional category of hate speech. And in fact, the only constitutional test we just heard says that hate speech is protected by the Constitution. Just as Holmes said, we must protect even the speech. I think, I'll read it again, we must be eternally vigilant against attempts to check the expressions of opinions that we loathe and believe to be fraught with death. So if there are a speech or opinions that we loathe or hate, and we believe to be fraught with death, even if we think it's so bad that it might even have a tendency to lead to violence, that's not enough to regulate it. Hate speech, according to Holmes and Brandeis, and that test from Brandenburg that I began by reading, is protected by the First Amendment. And in fact, the Brandenburg case, that 1969 case that I started with, that finally codified the Holmes and Brandeis test, involved hate speech. Amazingly, that was a case involving the Ku Klux Klan. And it was a guy who, talk about hateful, he's a member of the Ku Klux Klan. He gets up at a Ku Klux Klan rally in 1969, and he says something really hateful. He's in front of TV cameras. This is a guy called Brandenburg in 1964. And the cameras catch speeches and cross burnings, including one speech threatening what he calls revengeance against Jews, African Americans, and then this guy Brandenburg goes on to say, if our president, our Congress, our Supreme Court is suppressing the white Caucasian race, and they're planning a march on Washington. So this guy's saying, unless our president, our Congress, and our Supreme Court stop suppressing the white Caucasian race, then there could be revengeance against Jews and African Americans. And he's planning a march on Washington. Sound familiar? It's a version of what we just saw at the Capitol, where the people who stormed the Capitol had T-shirts and signs denouncing Jews and African Americans and others, and were threatening revengeance against what they called a stolen election. Nevertheless, this is the central point. It's totally counterintuitive. That speech, the Supreme Court said, was protected by the First Amendment because although hateful, it was not directed to or likely to produce imminent lawless action. It was a Ku Klux Klan rally. It was a long way away from Washington. They weren't actually going to march to Washington. It was a political rally, a hate rally, but it wasn't likely to produce any imminent violence, and therefore it was protected. So all of the debate we have today, and obviously it's one of the most important debates in our country today, about the circumstances under which hate speech can be banned online, for example, is all outside of the First Amendment framework. Facebook and Twitter and Google and YouTube all have their own policies defining and regulating hate speech. And my answer to your question, if you ask me what's hate speech, I'll say, well, let's go, tell me what platform you're asking about, and then we can just read their hate speech policies. But many of them have a version of bans on speech that insults or degrades people on the basis of group characteristics, including race, religion, or ethnicity. So on hate speech, on Facebook and on YouTube and Facebook, for example, you can criticize religious leaders, but you can't criticize religion. So a video where there was a scene in it which insulted the Prophet Muhammad, was considered protected because although it insulted the religious leader, it did not insult the religion. If it had insulted people of the Islamic faith, then it could have been banned. That's Google and Facebook's definition of hate speech. I really want you to, let's all pause to recognize the fact, if Google and Facebook are not the government, the First Amendment says Congress shall make no law. It doesn't say Mark Zuckerberg shall make no law. If Google were the government or Facebook were the government, it could not ban that speech that demeaned people of the Islamic faith. That speech would be protected unless it was intended to and likely to incite imminent violence. So you may think that that's the correct line. You may not think it's the wrong line, but you've got to understand what a strict line that is. And I'm just describing what the law is. The Supreme Court has said that hate speech, or speech that is hateful, or speech that expresses hate against a group or an individual, all of that speech is protected by the First Amendment unless it is intended to and likely to produce imminent lawless action, or rather directed to and likely to produce imminent lawless action. Now, the Supreme Court has carved out a narrow category of kinds of speech that are considered of low First Amendment value. And they include defamation, that's false statements that damage a person's reputation. So if you have something that's both hateful and false and contains a false statement of fact, that's defamation, and that can be actionable. A true threat, like a threat to commit a crime, I'll kill you if you don't give me your money or your life, that would be not protected. Fighting words, now what is that? That's face-to-face personal insults likely to lead to an immediate fight. That's the closest category that the Supreme Court is recognizing to allowing the banning of hate speech, but it all turns on the face-to-face idea that there are certain words that are so inflammatory that they're likely to produce an ordinary person to react with violence. Fighting words online have not been allowed to be banned because you can't happily, punch someone through a screen. So fighting words are a narrow category. And then there's commercial advertising, advertising a product or service that's considered commercial speech. So that's the answer to the question. There's no constitutional definition for hate speech. There's only a extraordinarily rigorous test that protects hate speech, but things are entirely different online and on platforms that are not regulated by the First Amendment.
You actually solved 4 of our questions with that. So well done, Jeff Rosen. And I know we're a little over time, but I just kind of want to wrap up with Colin's question in here because it really does bring a couple things together. When we are talking about speech, it's not just the verbal speech. It's not just standing or online and messaging people. So what about actions of the court what about actions that the court has construed to be speech, like burning the flag? How far does speech go before it's no longer just expressing an opinion that would be protected by the First Amendment? So many questions, and you just went through that really nicely. Like, where's the line? That's what I'm hearing from the students, like, where's that line? And that was great. Fighting words, face to face, all those things, because in this conversation, the time, the place, and the manner are all big areas that we have to focus on when we're looking at speech and the First Amendment overall.
Yes, time, place, and manner is important because the Supreme Court has said that content neutral regulations are permissible. So a time, place, and manner restriction is content neutral. I can say you can't protest outside the White House at 2 a.m. Using really loud microphones because that would wake everyone up. That's a time and a place and a manner restriction. I can't say you can't stand outside the White House yelling down with the president. That would be a content-based restriction, and that would be impermissible. Colin's great question, what about expressive advocacy or forms of symbolic speech? The Supreme Court has said a lot about, and it said that symbolic speech is protected, and flag burning is the great example. And in 2 cases, one called Johnson v. Texas, the Supreme Court said that standing on the steps of the Capitol, standing on a government building and burning the American flag is protected by the First Amendment because burning the flag is a symbolic form of protest. It's not actually speech. Gregory Johnson didn't yell down with the US when he burned the flag, but his act of burning the flag itself expressed his disapproval of the US government. That was a 5-4 decision. It was joined by the late Justice Antonin Scalia, showing that conservatives as well as progressives joined that decision. So the bottom line is that forms of expressive activity that may not involve actual speech, but nevertheless communicate a political message are covered by the First Amendment. And there's a whole doctrine of expressive advocacy that tries to draw those lines. Great question, Colin.
Great question, Colin. And James came with a boom, boom with, what about a draft card? So I was like, James, well done.
You can burn your draft card too, the US Supreme Court said. That is a protected form of political protest in the same way. And of course, we have to mention this because it involves schools. You can also wear a black armband to school protesting the war. That was the Tinker case. And that was the case where students were protesting the Vietnam War and they wore a black armband, and the US Supreme Court said, and this is the test that is so central to speech in the schools, the students are disciplined for wearing the armbands. They file a lawsuit. The decision is 7-2, Tinker versus Des Moines Independent Community School District. 1969, the same year as that Brandenburg case, which was a big year for free speech. And the court said that students, you retain your First Amendment rights while at school, as long as your speech or expressive acts, like the armband, don't materially or substantially interfere with the school's operation. There's no actual interference in Tinker. The school only feared potential disruption. That wasn't enough to survive a challenge. And the famous quote is, it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Now, all the action, friends, nowadays in the jurisprudence is, what does it mean to have speech that materially or substantially interferes with the school's operation and its central mission of teaching students? It's a test obviously less protective of speech than the Brandenburg test, which says that the speech has to be directed to and likely to produce imminent lawless action. But it's not completely open-ended. And of course, it's 100 times or 1,000 times more complicated to figure out in the age of the internet. If you post on a private chat, a post that says, Go protest at school. Don't go to class because you oppose this or that. Is that materially or substantially interfering with school operations if you're posting on your private chat? There was a recent case from the Third Circuit here at home, which the U.S. Supreme Court might take up this year, which held that speech sent on private text accounts was protected, and it couldn't be banned because it might have bad effects at school. The judges basically said if you could ban any speech sent from a private text that might disrupt school, then you students would have no free speech rights on your private text. Other courts have come out differently on the grounds that it doesn't really matter where your text is posted on a private chat board or text or Instagram or on a school board, as long as your fellow students are likely to see it, they might substantially and materially interrupt school discipline. This is a totally open area of law. My son got a great kind of moot court assignment for his con law class, trying to figure out an internet speech case at school. I'm sure many of you are struggling with these really fascinating questions too. You can argue either side, and it'd be a wonderful exercise, of course, either in class or outside of it, to come up with a hypo, or just use the Third Circuit case about when speech can be banned offline or online, argue both sides, and then maybe you'll help inform the debate as the Supreme Court decides whether or not to take up this really important question.
Awesome. That's fantastic. I think we are officially 11 minutes over. There's so many cases and so many great conversations. These First Amendment cases are fascinating, that you look over time at how things change and you really dig into the history and the people's kind of actions to look at what the First Amendment means to us and what does it mean to the courts and what is written down and how we understand it. So thank you so much, Jeff. This was a great class today. We're all really glad to have you in. And I wonder if your son will use Brandeis in his reference point into the right to be let alone in my text message as a teenager. So we will see. Thank you all very much. More questions, let us know. And Faye's great idea. We will send out a list of all the First Amendment court cases that you think you should check out so you can dive deep for your next Jeff work.
Thank you, friends. Thank you for studying and being inspired by the First Amendment. Thanks.
Thank you.
Talk soon. Bye.